Thank you for visiting the Waterkotte website and our Federal Child Exploitation and Pornography Lawyer in Missouri website page. Regardless of the crime, we believe everyone is entitled to the best possible legal defense in the state of Missouri. We have created this audio version of our website page to help you protect your future, freedom, and reputation. If you have been charged with federal child exploitation in the state of Missouri, we can help you. Don't face the state and court system alone during your federal child exploitation charge. Contact one of our federal child exploitation criminal defense lawyers today at 314-900-HELP to protect your rights and future. Waterkotte is committed to handling all child exploitation defense cases with confidential care and understanding. We are not here to judge you. We believe that everyone in Missouri, regardless of the crime they have been charged with, deserves an aggressive legal defense and to have their legal rights protected. With that being said, let's talk about being charged with federal child exploitation and pornography in the state of Missouri. Federal Child Exploitation and Pornography Lawyer in Missouri. Federal child exploitation and pornography charges carry some of the harshest penalties in the justice system, and the consequences begin long before trial. Just being accused can destroy your reputation, your career, and your relationships. If you're under investigation or have been charged in Missouri, you need a defense attorney who can respond immediately, protect your rights, and handle the case with both discretion and strength. Waterkotte provides experienced, judgment-free defense in both the eastern and western districts of Missouri from our offices in St. Louis and Kansas City. Why you need a Missouri federal child exploitation lawyer. Federal child exploitation and pornography charges are among the most serious offenses prosecuted in Missouri's U.S. district courts. A conviction can carry decades in prison, mandatory sex offender registration, and permanent damage to your reputation and relationships. These are not cases where you can afford delay, confusion, or inexperience. The federal government brings significant resources to these cases. Investigations are often led by agencies like the FBI, Homeland Security Investigations, or the Department of Justice. Prosecutors rely on extensive digital evidence and seek harsh mandatory minimums. If you've been contacted by law enforcement or believe you are under investigation, you need to speak with an attorney immediately before making any statements or decisions. Waterkotte's Missouri federal criminal defense lawyers know what's at stake. We defend clients across Missouri in high-stakes federal criminal cases with discretion, empathy, and strength. Our goal is simple: protect your future, your rights, and your dignity throughout every step of the process. What is considered child exploitation under federal law in Missouri? Under federal law, child exploitation refers to any act involving a minor under 18 that is intended to produce sexually explicit material or involves illegal sexual conduct for financial or other gain. These crimes are prosecuted under statutes like 18 U.S.C. Section 2251 and related sections in the Federal Criminal Code. These laws are intentionally broad and allow federal authorities to prosecute individuals for a wide range of conduct, whether it involves creating, facilitating, or knowingly allowing the exploitation of a minor. Examples of federal child exploitation offenses: coercing or persuading a minor to engage in sexual activity for the purpose of filming or photographing it, transporting a minor across state lines for unlawful sexual activity, allowing a child to be used in sexually explicit content, even indirectly, producing child pornography while overseas with intent to distribute it in the U.S. These charges can apply even in cases where the alleged activity took place online, across borders, or without direct physical contact. If you are accused of any involvement in the creation or facilitation of explicit content involving a minor, you are facing life-changing consequences and must act quickly to protect yourself. What counts as child pornography in Missouri federal court? Federal law defines child pornography as any visual depiction, including photos, videos, or digital files, of a minor under 18 engaged in sexually explicit conduct. These cases are prosecuted under laws like 18 U.S.C. Section 2252, which covers the production, receipt, distribution, and possession of such material. Importantly, a person can be charged even if they did not produce the content. Downloading, sharing, or storing it on a personal device is enough to trigger federal charges, and ignorance of the content's presence is not always considered a defense. Federal child pornography charges can include possession, having illegal material saved on a phone, computer, or other device; receipt or downloading, accessing or retrieving files across state lines via the Internet; distribution, sharing, uploading, or sending illegal content to others; production, creating or filming explicit content involving a minor; transportation or importation, moving illegal material across state or national borders. Any one of these offenses can lead to a federal indictment, and most carry mandatory minimum sentences. If you've been contacted by federal authorities or suspect you are being investigated, speak with a qualified attorney immediately before making any statements. Which federal agencies investigate these charges in Missouri? Federal child exploitation and pornography cases are typically handled by specialized investigative units within multiple federal agencies. These agencies often work together and with local law enforcement to build cases over time using forensic analysis, surveillance, and subpoenas. Common agencies involved in Missouri federal cases: FBI, Cybercrime and Child Exploitation Task Forces. Conducts digital forensic investigations and sting operations. Homeland Security Investigations, HSI. Focuses on trafficking, importation, and cross-border digital offenses. U.S. Department of Justice, DOJ. Leads federal prosecutions, often through its Child Exploitation and Obscenity Section, CEOS. U.S. Postal Inspection Service. Investigates cases involving physical media or shipping. These agencies have deep resources and access to sophisticated digital tools. If you are contacted by any of them or served with a warrant or subpoena, you should assume you are the subject of a serious federal investigation. Do not speak to agents without a lawyer present. Penalties for federal child pornography and exploitation in Missouri. Sentences for federal child pornography and child exploitation offenses are among the most severe in the criminal justice system. Convictions typically result in mandatory minimum prison terms, substantial fines, mandatory sex offender registration, and long-term restrictions on housing, employment, and Internet usage. Courts also commonly impose supervised release for up to life after incarceration. Base federal penalties. Production of child pornography, 15 to 30 years in federal prison. Mandatory minimum, 15 years. 18 U.S.C. Section 251. Distribution or receipt, 5 to 20 years in prison. Mandatory minimum, 5 years. 18 U.S.C. Section 2252. Possession, up to 10 years in prison for a first offense, and up to 20 years if the offense involves aggravating factors such as images of prepubescent minors or prior convictions. 18 U.S.C. Section 2252A. Repeat offenders. Mandatory minimums can increase to 25 years or more, and some offenses may carry a maximum penalty of life in prison. Fines, up to $250,000 per count, plus mandatory restitution to victims under the Amy, Vicky, and Andy Child Pornography Victim Assistance Act. Additional penalties. Sex offender registration. Mandatory under federal and state law, often for life, under the Sex Offender Registration and Notification Act, SORNA. Supervised release. Typically ranges from 5 years to life, with strict monitoring of online activity and residency. Employment and residency restrictions. Limits on living near schools, working with children, or accessing certain online platforms. Defending child exploitation charges in Missouri federal court. Being accused of a federal sex offense does not mean you are guilty. Every person charged has the right to challenge the government's case, and many federal child exploitation cases involve flawed assumptions, weak forensic evidence, or violations of constitutional rights. At Combs Waterkotte, we develop tailored federal criminal defense strategies based on the facts of your case, the strength of the prosecution's digital evidence, and any potential violations of your rights during investigation or arrest. Potential legal defenses in federal child exploitation cases. Unlawful search and seizure. Challenging the legality of search warrants, device seizures, or surveillance tactics. Lack of intent or knowledge. Arguing that the defendant was unaware of the material or did not knowingly access it. Third-party access. Raising doubt about who actually used the device or downloaded the content. Flawed or misinterpreted forensics. Disputing how files were found, labeled, or categorized. Entrapment or government overreach. In certain sting operations or induced interactions. These cases require precision, skill, and experience navigating federal law. Our firm works with expert witnesses, digital forensic specialists, and aggressive litigation tactics to uncover weaknesses in the government's case and pursue the best possible outcome. How Combs Waterkotte protects you against federal child pornography cases in Missouri. At Combs Waterkotte, we bring discretion, diligence, and deep experience to every federal child exploitation case we handle. These are not charges we take lightly, and they are never cases we handle carelessly. Our team moves quickly to assess the facts, manage public exposure, and build the strongest possible defense. Federal cases are complex. Multi-agency investigations, FBI, DOJ, IRS. Expert analysis of financial records. Multiple defendants or conspiracy overlap. Years of records under federal review. How we defend you. Challenge intent and digital interpretation. Dispute expert conclusions. Separate your role from broader claims. Protect your rights at every stage. Digital forensics experience in Missouri federal child exploitation cases. One of our attorneys, a former prosecutor, was selected by the U.S. Secret Service as one of just 25 prosecutors nationwide to complete advanced digital evidence training at the National Computer Forensic Institute. That background gives us a rare, inside understanding of how digital child exploitation cases are investigated and how to challenge them in court. Expert, experienced federal defense lawyers, Missouri child pornography charges. Our federal child exploitation and pornography attorneys understand how the government builds its case, and where those cases often break down. That insight helps us anticipate the prosecution's strategy, suppress damaging evidence, and present strong counter-arguments from day one. We bring that courtroom experience to every federal child pornography, and exploitation case we take on in Missouri, with a defense focused on facts, rights, and results. Contact a Missouri federal child exploitation and pornography lawyer today. If you're being investigated or have been charged with a federal child exploitation or pornography offense in Missouri, the most important step you can take is securing experienced legal counsel immediately and confidentially. Contact us online or call 314-900-HELP to schedule a fully confidential consultation with a Missouri federal criminal defense lawyer today.